Do you object to the court specifically saying that the officers have to have more than reasonable suspicion that an emergency is occurring?
I think we would object to it for a couple of reasons. I mean, one, I think because reasonable suspicion is a standard from the criminal law, just as probable cause is, for the reasons that Justice Kagan was just articulating with my friend, just pegging it to any one of these criminal investigation standards, I think, does more harm than good.
But why isn't that familiar? I mean, they're used to those standards. And so I appreciate that they do it in the criminal context when they're looking for crimes. But they understand, I would think, the difference between probable cause and reason, and I'm more focused on reasonable suspicion in that context. And so why couldn't we just say you have to have more than reasonable suspicion that an emergency is occurring?
Well, 2 points. First of all, police officers may be familiar with reasonable suspicion, but your standard here will also apply to firefighters, paramedics, all of whom may have no more familiarity with reasonable suspicion than with probable cause, and reasonableness is, I think, an easier standard to understand. Second of all, I do think, just given how varied emergencies are, it's best not to sort of set a floor at reasonable suspicion, just because this court can't really predict all of the manner of emergencies that could arise. And rather than hamstringing courts or officers with setting a floor on this, better to just stick with the objectively reasonable basis test from Brigham City.
Thank you.